In this video, we delve into the intricate world of law through the lens of 5 significant cases presided over by Associate Justice Mario Lopez, the esteemed chairman of the 2024 Bar's examinations. These cases are just a glimpse into the extensive repertoire of over 150 cases he has decided, showcasing his profound legal acumen and unwavering dedication to justice. Starting with Case 11, we explore the complex nuances of family law, specifically focusing on the declaration of nullity of marriage under the Family Code. Moving on to Case 12, we unravel the intricacies of labor law, examining the fine line between legitimate job contracting and labor-only contracting. Case 13 brings us into the realm of administrative law, questioning resolutions of the Court of Appeals in 2 related cases. Further, we dive into Case 14, which revolves around property rights and contractual obligations, highlighting the enforcement of contracts and resolution of property disputes. Lastly, Case 15 delves into administrative law, scrutinizing the boundaries of administrative authority and the rights of private entities. Each case presents unique insights into various aspects of Philippine law, making them essential for law students, legal professionals, and anyone interested in the legal system.
To get a more comprehensive understanding of these legal decisions and stay updated on similar content, we invite you to subscribe to our channel. Your support enables us to continue providing detailed and comprehensive legal discussions, enriching your knowledge and understanding of the law. Subscribe now and join our community for more insightful legal analyses. When is "till death do us part" not the end of a marriage? Can habitual gambling, alcohol abuse and domestic violence void a marriage? How did psychological incapacity cut short this supposedly lifelong commitment?
Find the answers in the recent case of Carolyn T. Samilhig versus Joselito T. Samilhig and Republic of the Philippines, GR number 230711, August 22, 2022. Part 11 of 160 of the decisions penned by 2024 Bar Chairperson Mario Lopez. Subscribe for more reviewers.
Facts of the case. Carolyn Samilhig filed a petition to nullify her marriage with Joselito Samilhig due to his psychological incapacity. She testified that Joselito was a habitual gambler and drunkard. He was also physically and verbally abusive, did not provide support for their family, and neglected their children. The trial court denied the petition, ruling that Joselito's behavior showed only neglect of duties, not psychological incapacity. On appeal, the CA affirmed. Issue of the case. Whether the totality of evidence presented sufficiently established Joselito's psychological incapacity to comply with essential marital obligations. Ruling of the case. The Supreme Court granted the petition and declared the marriage void ab initio. It ruled that the testimonies, corroborated by experts, clearly proved the juridical antecedents, gravity and incurability of Joselito's psychological condition, which rendered him incapable of complying with marital duties. The evidence satisfied the totality of evidence rule in psychological incapacity cases.
Important doctrines.
One. Expert opinion on psychological incapacity may rely on information from the aggrieved spouse who has personally witnessed respondent's dysfunction. Personal interview of respondent is not mandatory. 2. Under the totality of evidence rule, the court should consider all evidence presented to determine if taken together, they sufficiently prove psychological incapacity. 3. Juridical antecedents requires that the incapacity must exist at the time of marriage celebration, even if manifested later. This may be proven through testimonies on respondents' premarital behaviors. 4. Incurability pertains to incapacity so persistent that marriage inevitably breaks down. It need not be medical incurability. 5. Gravity pertains to incapacity caused by a serious psychic cause, not mere difficulties, peculiarities or ill will. Can your employer just pass you around without consequence? This man worked for 14 years as a messenger, only to find out he didn't even have a real boss.
This is the case entitled Palak Conjusta vs. PPI Holdings Inc. et al. GR number 252720, August 22, 2022.
This is case 12 of 160 cases decided by 2024 Bar Chairperson Mario Lopez. Subscribe for more reviewers.
Facts of case. Rico Palak Conjusta was hired by PPI Holdings Inc. PPI, in 2002 as a messenger. His employment was later transferred to a manpower agency CBMI. Despite the transfer, nothing changed in Conjusta's work. He continued as PPI's messenger for 14 years until CBMI terminated his services in 2016. Conjusta filed a legal dismissal against PPI and CBMI. PPI denied having an employer-employee relationship with Conjusta, asserting that CBMI was a legitimate job contractor. CBMI acknowledged Conjusta as its employee but denied terminating his services. The labor arbiter ruled that CBMI was a legitimate contractor but Conjusta was PPI's regular employee. The NLRC modified the ruling, declaring CBMI as labor-only contractor, making PPI and CBMI solidarily liable. On certiorari, the CA reverted, ruling CBMI as legitimate contractor based on stare decisis.
Issue of the case. Whether the CA erred in ruling that CBMI was a legitimate job contractor and Conjusta's direct employer.
Ruling. Yes, the court ruled that CBMI was engaged in labor-only contracting based on the circumstances showing PPI's control over Conjusta's work. PPI and CBMI were deemed solidarily liable as employer and agent respectively.
Doctrines of the case. One, declaration in previous cases that a company is an independent contractor is not conclusive basis to determine its status as such in another case. 2. Totality of facts and circumstances in each case must be assessed in determining if entity is labor-only contractor. 3. Certificate of registration as independent contractor is not conclusive proof of such status. 4. Where contractor does not exercise right to control employees' work, it is considered labor-only contracting. 5. In labor-only contracting, principal employer and contractor agent are solidarily liable.
The power of the Court of Appeals, CA, to issue a writ of preliminary injunction, WPI, against the implementation of a joint memorandum based solely on judicial courtesy.
This is the case of Leila M. de Lima, et al. Versus Hun. Court of Appeals, et al. GR number 199972, August 15, 2022.
This is case 13 out of 160 cases penned by the 2024 Bar Chairperson Mario Lopez, Associate Justice of the Supreme Court. Subscribe for more. Facts of the case. The Cagayan Economic Zone Authority, JZA, granted a license to Meridian Vista Gaming Corporation, Meridian, to operate high-ally gaming within the Cagayan Special Economic Zone. JZA later revoked the license, but the trial court issued a writ of mandamus allowing Meridian to continue operations. The Games and Amusement Board, GAB, subsequently ordered the closure of Meridian's off-fronton stations. Meridian obtained an injunction from the trial court against the closure order. GAB filed a petition for certiorari and prohibition with the Court of Appeals, CA, to nullify the injunction. The CA ruled that the trial court lacked jurisdiction and also affirmed GAB's regulatory authority over Meridian's high-ally activities. In separate proceedings, the DOJ and DILG issued a joint memorandum to prohibit and penalize Meridian's off-fronten operations. Meridian sought to enjoin the joint memorandum in the CA on the ground of judicial courtesy while related issues were pending in the Supreme Court. The CA issued a WPI against the joint memorandum.
Primary issue: whether the CA gravely abused its discretion in issuing the WPI based solely on judicial courtesy.
Ruling of the case. The Supreme Court held that judicial courtesy is not a ground for the issuance of a WPI. The CA should have lifted the WPI motu proprio upon the resolution of the related case. WPI may only be issued upon a showing of a clear legal right, which Meridian failed to demonstrate. Important doctrines. Principle of judicial courtesy applies only if the higher court's resolution would render the issues in the lower court moot, not merely related. Judicial courtesy is not a substitute for or ground to issue a WPI, which requires a clear legal right. The power to issue WPI must be exercised sparingly, with utmost care and caution. Can your assets be seized to pay someone else's debt? This bank found out the hard way when the court allowed its funds to be taken to pay another bank's judgment. The answer is found in the Supreme Court decision entitled Metropolitan Bank and Trust Company v. Radio Philippines Network, Inc. GR number 190517, July 27, 2022.
This is the 14th out of 160 cases decided by Associate Justice Mario Lopez, 2024 Philippine Bar Exam Chairman. Subscribe for more. Facts of the case. Traders Royal Bank, TRB, was ordered to pay damages to RPN, IBC, and BBC. TRB and Bankcom entered into a purchase agreement, depositing P50M in escrow with Metrobank. The SC affirmed the judgment against TRB. RPN, IBC, and BBC moved to execute against TRB's assets. The RTC issued a writ of execution against TRB's assets including the escrow fund. Metrobank questioned the writ against it since it was not a party. The CA upheld the writ. Issue of the case. Whether the writ can be issued against Metrobank's escrow fund despite not being a party.
Ruling of the case. The SC partially granted the petition. Under the rules, the sheriff must first demand payment from the judgment debtor before levying properties. The RTC erred in prematurely assuming jurisdiction over Metrobank and inquiring into the escrow fund. The sheriff must first serve a writ of garnishment upon Metrobank before the RTC can bind it.
Doctrines of the case. A money judgment is executed by first demanding payment from the debtor before levying properties. The court acquires jurisdiction over a garnishee through service of the writ of garnishment. Was this marriage doomed from the start? Find out why the Supreme Court declared this 20-year marriage null and void due to psychological incapacity. The case is entitled Jennifer A. Dedicatoria v. Ferdinand M. Dedicatoria and Republic of the Philippines, GR number 250618, July 20, 2022.
This is the 15th out of the 160 cases decided by Associate Justice Mario Lopez, 2024 Philippine Bar Examination Chairman. Subscribe for more.
Facts of the case. Jennifer A. Dedicatoria, Jennifer, and Ferdinand M. Dedicatoria, Ferdinand, were married on December 20, 1995. On October 23, 2014, Jennifer filed a petition for declaration of nullity of marriage due to Ferdinand's alleged psychological incapacity. Ferdinand failed to file an answer, so the case proceeded. During trial, Jennifer testified that after their marriage, they lived with Ferdinand's family, where she was made to do all household chores while Ferdinand remained unemployed and dependent on his parents. When Jennifer got pregnant, her father rented an apartment for them, but Ferdinand still opted to stay often at his parents' house. Their marital problems worsened after Jennifer gave birth, as Ferdinand remained jobless and uninvolved in caring for their child. In 1999, Jennifer left with their son and completely became estranged from Ferdinand. To prove Ferdinand's incapacity, Jennifer presented testimonies of their friend Ana Rose, Ferdinand's sister Teresita, and clinical psychologist Dr. Montefalcon, who examined them, except Ferdinand. Dr. Montefalcon diagnosed Ferdinand with dependent personality disorder, making him incapable of performing marital duties. The RTC declared the marriage void, but on appeal, the CA overturned the ruling for insufficiency of evidence regarding the juridical antecedents, gravity and incurability of the incapacity.
Issue: whether sufficient evidence was presented to prove psychological incapacity for the court to declare the marriage void.
Ruling. The Supreme Court granted the petition and reinstated the RTC ruling. It ruled that the totality of evidence presented through the testimonies of Jennifer, Ana Rose and Dr. Montefalcon sufficiently proved that Ferdinand is psychologically incapacitated. The witnesses' narrations established that Ferdinand's extreme dependence on family, ingrained since childhood, rendered him unable to function as a husband and father. This sufficiently proved the juridical antecedents, gravity and incurability of his incapacity. Important doctrines. (1) Psychological incapacity is a legal concept, not a medical diagnosis. Clinical evidence is not indispensable. Totality of evidence must show spouses' enduring dysfunctional behavior existing before marriage rendered them incapable of marital duties. 2. Witnesses who knew the spouse before marriage can testify on behaviors indicative of incapacity. No need to examine both spouses to prove psychological incapacity. 3. Incapacity must be grave, not just mood changes or emotional outbursts. It must also be incurable in the legal sense of being so embedded in spouse's personality structure,